Greetings, this is Dr. Welch again, and our topic today concerns discrimination claims, Equal Employment Opportunity Commission proceedings, and other matters pertaining to discrimination. The first question would be, what are the protected classifications? Well, we know it's age, race, color, national origin or ancestry, sex or gender, pregnancy, marital status, religion, medical condition and mental disability, sexual orientation, equal pay, citizenship, armed forces service, and genetic information. Now, it depends how many employees often an employer has in terms of whether they are bound by certain laws. The question next is, how many employees must a company have for Title VII, including the Pregnancy Discrimination Act of 1978, to apply? The answer is 15 or more employees. The next question, how many employees must a company have for the age, AGE, Discrimination in Employment Act to apply? The answer is 20 or more on each working day for 20 or more weeks. The next question, how many employees must a company have for the Americans with Disability Act, often called ADA, to apply? The answer is 15 or more. How many employees must a company have for the Family and Medical Leave Act to apply? The answer is 50 or more. The next question, what is a prima, P-R-I-M-A, facie, F-A-C-I-E, case? Prima facie means that when a plaintiff proves certain facts by a preponderance of evidence, that's usually about 51%, the plaintiff is entitled to damages or other relief against the employer, subject to the employer's proof of a defense to the plaintiff's allegation. Preponderance of evidence means that the plaintiff's evidence established that the claim of employment discrimination is more likely to be true than not, such as if the scale is tipped in that favor. What is direct evidence? Proof that establishes a fact by itself, such as an employer's statement that it discriminated against an employee. And then we ask, what is circumstantial evidence? That is proof that establishes a reasonable inference or presumption that discrimination occurred. The use of circumstantial evidence allows a trier of fact to infer that unlawful employment discrimination has occurred. Now, continuing on, what is an affirmative defense and what are examples of it? A legal rule that allows the defendant to win the case even though the plaintiff proved a prima facie case. It is the legal principle that limits or excuses a defendant's liability because of superseding facts or a strong public policy. Now, getting to some questions to actually test this area. The first question, question 1, the Equal Pay Act is part of the FAIR, F-A-I-R, Labor Standards Act. That is true. 2, the Equal Pay Act would allow differences in wages to be paid if the wage differential was due to a differential based on any factor other than gender, and that would be true. The Equal Pay Act only applies in 2 areas, where you have the pay must be equal and gender. It applies to gender. This was passed in 1963. So if you're an employee and you're a woman and you're being paid a lower amount than a man doing the same job, that may be in violation of the Equal Pay Act. 3. In cases of affirmative action, the courts have sometimes held that discrimination in favor of a minority worker may be legal. That is true. California recently passed a rule that in the state area we no longer have affirmative action. However, on federal contracts, affirmative action still exists, and minorities can be given a preference. One defense provided by statute to charges of Title VII violation is that of a bona fide seniority or merit system. That's true. 5. Congress requires equal pay for comparable work under the Equal Pay Act. That is false. The word that makes it false is comparable worth. What happens in the comparable worth jurisdiction is plumbers and secretaries are paid like different amounts, but what they try and do is equal the pay of a secretary, because most women are secretaries, with that of a plumber, because most males may work in the plumbing area, and that isn't the law pertaining to the Equal Pay Act. The Department of Civil Rights is the federal agency responsible for enforcing Title VII. That would be false. It's the EEOC. If you have a complaint, you can call the EEOC office of your county to make a complaint. Next, an employer may ask all employees during an interview if they have children, as long as the rule applies equally to men and women. Well, that generally is not a good question to ask. You may ask them, do you see any problem of getting here at 8 o'clock in the morning? And someone may say, oh, I have 5 children to get ready. I see a big problem. So those are the type of questions that should be asked. Next, the Equal Pay Act means that an employer does not discriminate on the basis of race, color, creed, or national origin. That would be false, because it is Title VII that relates to prohibition against discrimination based on race, color, creed, national origin, and gender. When that act was passed, some senators said, why don't we put sex in there? And that has been a big area of litigation of Title VII when it was included. A Playboy club can hire female cocktail servers rather than male cocktail servers and not be in violation of Title VII. That is probably a BFOQ, meaning a bona fide occupational qualification, that men go to the Playboy club to see women that look like bunnies, and so that may be permissible under a BFOQ. So this will be the end of this tape, and then we'll go on for further questioning on the next tape.